You believe that your doctor was careless, and now you have it in your mind that you want to go ahead and bring a lawsuit. Can you go ahead and do that? Can you bring a lawsuit for medical malpractice if you believe that your doctor was careless? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. In order to answer that question, I have to ask one additional question that will likely stop you in your tracks. Now, why do I say that? Because in New York, in a medical malpractice case, it's not sufficient to simply say, okay, the doctor was careless, and therefore I want to go ahead and bring a lawsuit. No, that's not how it works. In fact, there are 3 different components to determining initially whether or not you may be able to bring a lawsuit for medical malpractice. The first, only the very first question is, was the doctor careless? We say, did the doctor depart from the standard of care, right? Another term is, was the doctor negligent? Those questions are all the same question. Did the doctor do something he should not have done? If the answer is yes, the next question we have to answer is, was the doctor's carelessness a cause of your injury? There has to be a link between whatever the doctor did wrong and you suffering some type of injury. That's the second component of what we need to evaluate. And the third question that will likely stop most people in their tracks is, what permanent physical injury did you suffer as a result of this doctor's carelessness? Most injured victims, most injured patients who perceive that the doctor did something wrong never get to the stage where they have to think about what permanent physical injury they suffered as a result of the doctor's wrongdoing. They are so focused on what the doctor did wrong, they tend to overlook or to ignore the fact that they also need to know what permanent physical injury or harm they suffered as a result of the doctor's carelessness. In legal terms, I have to evaluate first liability. Is the doctor responsible? Number 2, I have to evaluate something called causation. That's the link between the doctor's carelessness and your injury. And then number 3, I have to evaluate damages. What permanent physical harm and injury did you suffer as a result of this doctor's carelessness? If the answer is little to none, in all likelihood, I will not be able to help you. And you'd have to try and reach out to another attorney to see if they would be willing to evaluate your case. So just because you perceive or you believe that a doctor was careless and you slipped through the cracks, the question then becomes, okay, so what physical harm and injury did you suffer as a result of that? If the answer is nothing, or something very little, or something very minor, you are going to have a very difficult, challenging time trying to find an experienced attorney to take on and investigate your case. So why do I share this quick video with you? I share it with you because most people who think that they've been harmed by a doctor in New York think that that automatically means that they can go ahead and start a lawsuit. The answer is no, that's not how it works. You know, I recognize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do, if you have significant physical harm and injury, I invite you to pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.